Good evening to everyone. I have the pleasure of reintroducing Shri D.R. Venkat Sudarshan, retired district judge. He was my guru too. I have learnt a lot under him. Today's session is devoted to child custody and guardianship under Mohammedan Law. We have learnt from him about inheritance under Mohammedan Law in the previous session. This is the part two of that. I welcome you to the session, sir, and I also welcome all the learned mediators and my colleague Sri Gudi Vasudev to this program. I request you to take over, sir. Thank you.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Very fine good evening to one and all. Today's subject regarding child custody is the continuation of the subject which we have discussed in the previous session, that is inheritance under Mohammedan law. We have already discussed about this subject in the previous session, and for want of time we could not take up this subject regarding child custody on that day. Any problem, sir? Okay, thank you. Now, today, Madam has given me this opportunity of standing before you again in this beautiful evening and share my few thoughts. I don't say giving lecture, share my few thoughts on this subject. You are all officers of the court, the learned advocates. So, I am conscious of the fact that there are senior advocates who are more knowledgeable and highly informed than what I know. So, whatever the little thing that I know, and out of my experience, I would like to share my few thoughts on the subject. The subject is very sensitive: custody of the child. When we talk of custody of the child, many things come to our mind. Today's child is tomorrow's citizen. Wordsworth says, "Child is the father of a man." So, a well nurtured, nourished, brought up by providing a value based education, making him a good citizen, and contributing that child to the society is the important job of the parents or the guardians, as the case may be. the welfare of the entire community, it is said, the welfare of the entire community, its growth and development depends on health, strength, and well being of its children. I'm just giving a introductory note because you are all mediators, and many a times emotional things will come into picture. So, therefore, we should also keep in mind as to why the child custody plays an important role, even for a mediator, also, in order to encourage the parties to a litigation to arrive at a proper settlement. I once again repeat what I have read. The welfare of the entire community, its growth and development depends on the health, strength, and well being of its children. The prosperity and development of any country certainly depends upon the human development or the well being of its people in general and children in particular. And children in particular, than the development of their military or economic strength or splendor of their capital cities and public buildings. So they always relegate to the second seat, military, economic strength, splendor of their capital cities, public buildings. All those things are relegated to a back seat when the question of importance to be given to a child is concerned. So the importance that is given to a child is in the best interest of the in the best interest of maintaining a good society, a healthy society, a good citizenry. The children are the greatest gift to the humanity, and they are the representatives of the beautiful, they are the representation of the beautiful creation of God. They are innocent, weakest, defenseless, and most vulnerable segment of the society. Unfortunately, they are subject to all forms of abuse from which they are to be protected. That is the need of the hour. If proper protection is provided and their safety security is taken care of at each level of their growth by providing proper value based education to them, they could be our future scientists, administrators, rulers, engineers, advocates, judges, philosophers, legislators, technologists, industrialists, and so on and so on whom the nation rests. Therefore, the custody of the child is of a great concern to every one of us in the society, keeping the future development of the society or the nation in general. Honorable Justice Shivraj B. Patil, the former judge of the Supreme Court of India, in his preface written to the book titled Child Labor in India Legal Regulations, written by Dr. Lingaraj M. Koninkar, the former professor of law and the principal of SSL Law College, Gulbarga, and director Childline 1098, Nodal Center, has observed thus. This is the observation made in the preface, written by His Lordship, Justice, Honorable Justice Shivraj B. Patil. Quote, children are the supreme asset of any nation. Children are the supreme asset of any nation. They being the greatest gift to the humanity, children are potential and useful human resources for the progress of any country. They are to be looked after and groomed well, not merely because of the constitutional or statutory provision, not merely because of any constitutional or statutory provision, but also with a great human touch and concern. We have both the obligation and duty towards them. This is what the Honorable Justice Shivraj Patil, His Lordship, has written in the preface to that book. It is in this context that proper custody of the children for grooming them is of greatest importance. The Honorable Supreme Court of India in Jacob versus Jacob reported in 1975 Supreme Court cases, page 840, observed thus: children are not mere chattels. Children are not mere chattels, nor they are mere playing things for their parents, nor they are mere playing things for their parents. In another judgment of the Honorable Supreme Court, reported in 1984, Volume 3, SCC 161, in Bandhu Mukti Morcha versus Union of India and others, the Honorable Supreme Court has observed this: neglecting the children means loss to the society as a whole. Neglecting the children means loss to the society as a whole. If the children are deprived of their childhood, socially, economically, physically, and mentally, the nation gets deprived of the potential human resources for social progress, economic empowerment, and peace and order, the social stability and good citizenry. The founding fathers of the Constitution therefore have bestowed the importance of the role of children its best for their development. So this introductory note perhaps make us to understand as to why child custody is most important in cases where the child is actually deprived of love and affection by the parents or the guardian, and where we may have to decide as to whom the custody of the child will have to be given and who will take care of the best interest of the child, the welfare of the child in the long run. Now, coming to the subject of the day, in fact, perhaps the value based education to the children has been considered as of utmost importance. Of course, all of you are advocates here, though it is little out of context. I may make a mention here that in a book titled Be Immortal, written by Honorable Justice V. Ramajoyce, my lord, in a book called as Be Immortal, written on the 150th anniversary of Swami Vivekananda. In one of the pages, His Lordship has mentioned about the fact as to how education has been made a fundamental right to a citizen under Article 21A of the Constitution of India. All of us know that in the Constitution which was originally introduced, education was not a fundamental right. In a judgment of the Honorable Supreme Court, reported in AIR 1993, Supreme Court, page 2178, Unnikrishnan versus State of Andhra Pradesh. The matter which came up for one of the matters which came up for discussion was whether education should be made as a compulsory thing, a fundamental right to be given to all children. The Honorable Justice V. Ramajoyce, in his book, as I told you, Be Immortal, says that in the course of the argument, a Sanskrit Subhashita written by Bhartrhari was addressed. That Subhashita runs like this: Vidyanama narasya rupamadikam prachanna guptam dhanam Vidya bhogakari yashas sukakari Vidya gurunam guru Vidya bandhujano videsha gamane Vidya para devata Vidya rajasu pujita Natudanam Vidya vihina pashuhu. Most of us know only the last sentence, and the rest of the Subhashita may not be known to us. I don't say none of you are aware of it, may not be known to most of us. Vidya nama narasya rupamadikam prachanna guptam dhanam Vidya bhogakari yashas sukakari Vidya gurunam guruhu Vidya bandhu jano videsha gamane Vidya paradevata Vidya rajasa pujita natudanam Vidya vihina pashuhu. What is the meaning of this? Education is the special manifestation of a man. Man includes woman also. Education is the special manifestation of a man. Education is the treasure which can be preserved without fear. Education is the treasure which can be preserved without fear. Education secures material pleasure, happiness, and fame. Education is the teacher of teachers. Gurunam Guruhu. Education is one's friend when he goes abroad. Education is the God incarnate, and education secures honor at the hands of the state and not the money. The state always honors a person who is educationally strong, maybe need not be only qualified, even music, literature, everything is included here. Dance, music, literature, philosophy, story, everything is included here. So it is only such people who are honored by the state and not the person who is wealthiest man who will be honored like that. That is the value of the education. And a man without such education is like an animal. This is the shloka of Bhartruhari, the greatest Sanskrit poet. Hmm. Madam, ಏನಾದ್ರು ಹೇಳ್ತಾ ಇದ್ರೆ ತಾವು? Okay. So why I'm emphasizing on this is the Honorable Supreme Court in the book it is written like that. The Honorable Supreme Court after hearing this, in fact, you can see the judgment. Whatever that I have stated in English has been reproduced in the judgment. And the Honorable Supreme Court after saying that has said further there is nothing more to be added so far as the value of importance and value of education is concerned. And based on that judgment, the Parliament, by its 86th Amendment, which came into effect on 12/12/2002, inserted Article 21A into the Constitution in Part number 3, which says it shall be the duty of the state to provide free and compulsory education to all children in the age group of 6 to 14. So the free and compulsory education was introduced as a fundamental right in the Constitution by inserting Article 21A in Part 3. I am telling this because we as mediators, we must be aware of this provision. We must be aware of the background under which this provision has come into force. Tomorrow, when we have been asked to conciliate or of course, mediators are not conciliating. I know that they have got a limited role to play, but you have got duty to explain to the persons, the parents or whoever it is, that this is the so who is capable of giving a value-based education to the children is also an important factor to be taken into consideration while considering the custody of the child. Therefore, in order to make that to understand ourselves, I have quoted this. This is not the part of the subject which we are discussing. Now, coming to the child custody under Mohammedan law, it is discussed in chapter 17 of this Principles of Mohammedan Law by Mullah. This is the book which I have referred. It commences from, you can call it as an article, section, or whatever you want, 348. In 348, it is stated, minor means a person who has not completed 18 years of age. But under Mohammedan law, both in the Hanifas and Shias, attainment of puberty is presumed to terminate minority of both males and females. Under the Indian Majority Act, 18 years. On attainment and completion of 18 years, a person is said to be, till the completion of 18 years, a person is said to be a child. But under Mohammedan law, on attainment of puberty of both male and female, the minority terminates, comes to an end. Further, it is stated, puberty is presumed to have attained on completion of 15 years. So, whether a male or a female, when they complete the age of 15 years, it is presumed that they have attained puberty and the minority has ceased to exist, terminated. But this is important. An exception to this is applicability of Indian Majority Act. Indian Majority Act of 1870 is an exception to this because in section 2 of the Indian Majority Act, it is stated, nothing in this act shall affect capacity of any person to act in the following matters: marriage, dower, divorce, and adoption. That means For these categories, the Indian Majority Act is not applicable. So, by implication, custody of the child has been taken away. That means, though Mohammedan law says that on attaining the age of 15 years, the person attains puberty and the minority terminates, because of the application of the Indian Majority Act to the cases of child custody, it is 18 years only which has to be taken into consideration and not 15 years, number one. Number two, Indian Majority Act being a special act enacted for a particular person, it always prevails over the general law. This is the general interpretation of statutes. All of us are aware of this. So, Indian Majority Act applies to all matters of Mohammedan except marriage, dower, divorce. So, custody of the child has to be followed according to the provisions of the Indian Majority Act only and not Mohammedan law. Then, Article 349 speaks of all applications for appointment of guardian of the person or property of a minor shall be made under the Guardians and Wards Act only. This is what is found in Mohammedan law. All applications for appointment of guardian of the person or property of a minor has to be made under the Guardians and Wards Act of 1870 only, 1890 only. Because there may be some confusion. When Mohammedan law say 15 years, Indian Majority Act says 18 years, which will have to be applied. That has been made very clear by Section 2 of the Indian Majority Act itself, and also Section 349. I call it as a section or article of Mohammedan law, that the application for child custody will have to be made only under the provisions of the Indian Majority Act. Any person entitled to be a guardian by the Mohammedan law may act as such without any previous order of the court. This is what is found in the Mohammedan law. That is, any person who is entitled to be a guardian by Mohammedan law, this is very important, entitled to be a guardian by Mohammedan law, may act as such without an order from the court. But nothing prevents him from making an application to the court under Guardians and Wards Act, seeking his appointment as a guardian or to declare him as a guardian. So, such of those persons who are entitled to act as a guardian of a Mohammedan child can do so even without an order of the court. But nothing prevents them from making an application to the court to appoint them as guardian or to declare them as guardian. Now, what do you mean by saying entitled to be a guardian under the Mohammedan law? For this, we should see the relevant provisions of the Mohammedan law, which entitles a person or persons to be the guardian of a Mohammedan child. These sections are, of course, I am going to discuss about it. Article 352, right of mothers to the custody of an infant children. Article 353, right of female relations in default of mother. There are 10 relations. Article 354, females when disqualified for custody. Article 355, right of male paternal relations in default of female relations. There are 10 relations. Article 356, custody of the child wife, that is minor wife, who is married. Wife is married only. Article 357, right of father and paternal male relations to the custody of a boy over 7 years and of a girl who has attained puberty. Article 358, custody of the illegitimate children. This is so far as the custody of the person of the minor is concerned. Custody of the person of the minor is concerned. I am not talking about the property of the minor. Custody of the person of the minor is concerned. So far as the guardian for the property of the minor is concerned, Article 359, legal guardians of property. Article 360, guardian of property appointed by the court. Article 361, de facto guardian. Article 362, alienation of immovable property by a legal guardian. Article 363, alienation of immovable property by guardian appointed by the court. Article 364, alienation of immovable property by a de facto guardian. Article 365, agreement by guardian for purchase of immovable property for his ward, that is to the minor. These are the important sections, according to me, under the Mohammedan law, which has to be read along with the Guardians and Wards Act for the better understanding of the applicability of the provisions so far as the custody of the children is concerned. Now we will make a brief discussion on each and every article mentioned here. I told you Article 349 speaks of application for appointment of a guardian. All applications for appointment of a guardian of the person or property or both of a minor or both of a minor are to be made under the Guardians and Wards Act of 1890. Article 350 speaks of power of the court to make order as to guardianship. When the court is satisfied that it is for the welfare of the minor, that an order should be made appointing a guardian of his person or property or both. Number two, declare a person to be such guardian. The court may make an order accordingly. So, declaration of a guardian. A person is a guardian. Article 351. Matters to be considered by the court in appointing guardian. In appointing or declaring the guardian of a minor, the court shall, subject to the provisions of this section, be guided by what consistently with the law to which the minor is subject appears in the circumstances be for the welfare of the child. This is very important. So the paramount consideration which has to be kept in mind by the court is the welfare of the child. Sometimes both the parents may not be eligible to have the custody of the child because of various reasons. The court may have the opinion that either the father or the mother both may not be able to properly nourish the child and bring up the child. Then the court may appoint some other person as the guardian. That is why, what is the welfare of the child? What do you mean by the welfare of the child? Has been well explained in one of the judgments of the Supreme Court. Of course, there are a number of judgments. In one of the judgments of the Supreme Court, reported in AIR 2019, Supreme Court, page 557. Gaurav Nagpal versus, of course, though it is a decision under the Hindu law, Hindu Guardianship Act. The 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 important aspects which are mentioned there are applicable to any child of any religion. Therefore, I am bringing this decision. May not be a mistaken that why I am referring the decision under the Hindu Minority and Guardianship Act. Gaurav Nagpal versus Sumedha Nagpal. The word welfare, I am quoting the judgment. The word welfare under section 13 of the Hindu Marriage and Guardianship Act 1956 has to be construed literally and must be taken in its widest sense. The moral and ethical welfare of the child must also weigh with the court as well as its physical well-being. This is a very, very important section which decides the entire aspect. The moral and ethical welfare of the child must also weigh with the court as well as its physical well-being. Though the provisions of the special statutes which governs the rights of the parents or guardians to be taken into consideration, there is nothing which stands in the way of the court exercising its parents' patriae jurisdiction arising in such cases. So even though there are parents, the court has got duty to examine whether either the father or the mother are capable of taking care of the child, upbringing the child, nurturing the child, and bringing up the child. So, if the court is of the opinion that it is not so, then as a parent's patriae, the court can take its own decision in the matter. But absolute rights of parents over the destines and the lives of their children in the modern changed social condition yield to the considerations of their welfare as human beings so that they may grow up in a normal balanced manner to be useful members of the society. And the guardian court here refers to court as the guardian court, in case of disputes between mother and father, is expected to strike a just and proper balance between the requirements of welfare of the minor children and the rights of their respective parents over them. Parents may be having right to have the custody of a child, but while keeping the welfare of the child in mind, if the court feels that it is not safe to leave the child with the with either of the parents, then the court can take a decision of its own. It has also been stated that if the minor is of any age to exercise choice, the court will take his wishes into consideration. That is, if the child has reached, for example, an age of discretion, if the child is able to choose between X and Y, the father and mother with whom the child wants to go, the court can also take the view of the child into account. It is further observed an incidental aspect. It is further observed as an incidental aspect, which has a bearing on the question, may also be adverted to in determining whether it will be for the best interest of the child to grant its custody to the father or the mother. The court may properly consult the child if it has a sufficient judgment. That is, if it is capable of making a judgment, the court can take the opinion or the consult the child also while giving custody to either of the parents, either any one of the parents or parents. So, in considering what will be for the welfare of the minor, the court shall have regard to the age, sex, and religion of the minor, the character and capacity of the proposed guardian, and his nearness of kin to the minor, the wishes, if any, of a deceased parent, and any existing or previous relations of the proposed guardian with the minor or his property. Because it is always believed that instead of giving a child to the custody of a stranger who may not be having that much of affinity with the child, it is always better to give a child to a person to whom he is related. Because a person who is related to that child either through the father or through the mother will, it is believed that he will take maximum interest or more interest in protecting the interest of the child. Therefore, the judgment says that, therefore, this particular clause 2 of section 351 says, in considering what will be for the welfare of the minor, the court shall have regard to the age, sex, and religion of the minor, the character and capacity of the proposed guardian, and his nearness of kin to the minor, the wishes, if any, of a deceased parent, and any existing or previous relation of the proposed guardian with the minor or his property. If the minor is old enough to form an intelligent preference, the court may consider that also. This is what is exactly found in section 17 of the Guardians and Wards Act also. Now, when the question, I told you, 349, any person entitled to be a guardian. Now we will see who are all the persons entitled to be the guardians. Section 350, Article 352 of the Mohammedan Law. A right of a mother to custody of an infant children. The mother is entitled to the custody, that is Hizanat, of her male child until he has completed 7 years. Male child until he has completed 7 years. And of her female child until she has attained puberty. So, if it is the child is a male child, the mother is entitled by the operation of law itself to have the custody till it completes the age of 7 years. If the child is a female child, till she attains puberty, that is 15 years of age, as per the Mohammedan law. The right continues, though she is divorced by the father of the child. So the divorced wife will have that right of of having the custody of a male child till he completes 7 years, and a female child till she completes 15 years of age, puberty. The right continues, though she is divorced by the father of the child, unless she marries a second husband, in which case the custody belongs to the father. So if she takes a second husband after divorce, then the custody of the child will go to the father of the child. This is one section which is covered under section 349 under the phrase entitled to be a guardian. Then the next section is, I am not going in detail into each and every section because of the time constraint. Section 353, right of female relation in default of mother. Section 352 speaks of entitlement of a mother to the custody of a male child who has not completed 7 years, and a female child who has not reached the age of puberty. Supposing in the absence of a mother, who are the persons who are entitled to the custody of a male or a female child? Failing the mother, that is in the absence of the mother, the custody of a boy under the age of 7 years and of a girl who has not attained puberty belongs to the following females. There are 10 relations set out in this particular Article 353. They are mother, mother's mother, sorry, mother-in-law, because in the absence of mother only, mother's mother, how high soever she may be, father's mother, how high so she may be, full sister, uterine sister, consanguine sister, full sister's daughter, uterine sister's daughter, consanguine sister's daughter, maternal aunt in like order as sisters, and paternal aunt also in the same order as sisters. So look at this provision. All the 10 relations are female relations only. So a male child who has not completed 7 years and a female child who has not attained puberty, in the absence of a mother, can be given to the custody of any of these relations who are only females. So, the purpose and the object behind giving a male child of less than 7 years and a female before attaining majority is very much enlarged in this section 353. Then, section 354. Females when disqualified. Okay, we have seen section 351, which says mother is entitled for custody. We have seen section 352, which says in the absence of the mother, who are all entitled to have the custody of the child. But section 350, article 354 says when a female is disqualified to take custody of a child, a female, including the mother. So look at this section. So this is applicable both for section 352 and article 352 and 353, including the mother who is otherwise entitled to the custody of a child, loses right to custody. Number one, if she marries a person not related to the child within the prohibited degrees. Example, if she marries a stranger, but the right revives on the dissolution of the marriage by death or divorce. What do you mean by this? Either the mother or any of the female relations mentioned in Article 353. If there, if that lady marries a person who is a stranger or who is not related to her, who will not come under the prohibited degrees of relationship under Article 260, 261. We will come to that later. Who are all the relations coming under prohibited degree of relationship? Will come. Then such person is disqualified. She cannot claim the custody of a child. No, thank you, thank you. Good, good. Thank you. Or if she goes and resides during the subsistence of the marriage at a distant place from the father's place, if that female is residing at a far off place, then she is also not entitled for custody. If she is leading an immoral life, an adulterous life, or where she is leading her life as a prostitute, even then she is not entitled to have the custody of a child. And lastly, if she neglects to take proper care of the child. So, neglecting to take proper care of the child. Here, with permission, I would like to state one Subhashita which says as to how a child should be taken care of. Lalayat panchavarshani dashavarshani tadayet. ಪ್ರಾಪ್ತೇಶು ಷೋಡಶೇ ವರ್ಷೇ ಪುತ್ರಂ ಮಿತ್ರವತ್ ಆಚರೇತ್ ಅಂತ ಒಂದು ಸುಭಾಷಿತ ಇದೆ. ಮಕ್ಕಳನ್ನ ಹೇಗೆ ನೋಡ್ಕೋಬೇಕು ಅಂತ. ಲಾಲಯತ್ ಪಂಚವರ್ಷಾಣಿ, 5 ವರ್ಷ ಆಗೋವರೆಗೂ ಮಗುನ ಚೆನ್ನಾಗಿ ಮುದ್ದು ಮಾಡ್ಬೇಕಂತೆ. ಯು ಹ್ಯಾವ್ ಟು ಫಾಂಡಲ್ ದಿ ಚೈಲ್ಡ್ ಲೈಕ್ ಎನಿಥಿಂಗ್. ಯು ಹ್ಯಾವ್ ಟು ಪ್ಯಾಂಪರ್ ಇಟ್. ದ ರೀಸನ್ ಈಸ್ ದ ಚೈಲ್ಡ್ ಮಸ್ಟ್ ನೋ ಹೂ ಆರ್ ಆಲ್ ಇಟ್ಸ್ ಕ್ಲೋಸ್ ರಿಲೇಷನ್ಸ್, with whom it can move. So therefore, up to the completion of 5 years, you must pamper the child. ಚೆನ್ನಾಗಿ ಮುದ್ದು ಮಾಡಿ ಬೆಳೆಸ್ಬೇಕಂತ 5 ವರ್ಷ. ದಶವರ್ಷಾಣಿ ತಾಡಯೇತ್. ಅದಾದ 10 ವರ್ಷಕ್ಕೆ, 5 ವರ್ಷ ಆದ್ಮೇಲೆ 10 ವರ್ಷದವರೆಗೂ ತಾಡಯೇತ್ ಅಂದ್ರೆ ಹೊಡಿಬೇಕು ಅಂತಲ್ಲ, ಹೊಡೆದು ಬುದ್ಧಿ ಹೇಳುವಂತ ಸ್ಟೇಜಲ್ಲಿ ಇಟ್ಕೋಬೇಕು. ಯಾಕೆ? ದಟ್ ಈಸ್ ದಿ ಏಜ್ ವೇರ್ ದೇರ್ ಇಸ್ ಎ ಪಾಸಿಬಿಲಿಟಿ ಆಫ್ ದಿ ಚೈಲ್ಡ್ ಗೆಟಿಂಗ್ ಡೈವರ್ಟೆಡ್ ಟು ಎ ಬ್ಯಾಡ್ ವೈಸಸ್, ಟು ವೈಸಸ್. Therefore, the obligation is there on the parents or the guardian to take proper control of the child between 6th year and another 10 years, up to 16 years, let us say, the age of adolescence. An age of adolescence is, it's a very wild horse age. So therefore, the parents will have to control. Prapteshu shodashe varshe. After 16 years, putram mitravat achare. Treat him like a friend. Treat him like a friend. So, if you want to treat your son or a daughter as a friend, we as parents have duty to bring the parents up to that, children up to that level. A child cannot become a friend all of a sudden to a father or a mother. So a child, when you want to treat a child as your friend, that is, the child should be able to understand your wavelength and your capacity, your position and everything, and he should behave like. So this is how a child will have to be taken care of. If there is a negligence on the part of the parents in taking care of the child, that's what it's. If she neglects to take proper care of the child, she is not entitled for custody. She takes the child to her custody and send the child for child labor, or earn money out of some illegal ways. One cannot say that she is taking proper care of the child. So then she is disqualified from taking custody of the child. This is so far as section 354 is concerned. Now females we have seen. Mother has got a right to take the custody of the child. A male child who has not completed 7 years, a female child who has not attained the age of puberty. That is a general right given to the mother. In the absence of the mother, there are 10 relations which I have narrated in section 300, article 353. In article 353, even though there are such relationships, when we can say that they are disqualified from taking custody of the child. Now, come to the male side. Article 355. Right of male paternal relations in default of female relations. So when there is no mother, when there is none of the relations mentioned in 10 relations mentioned in section 353, then who else can have the custody of the child? In default of the mother, that is section 352, and in default of the female relations, that is section article 353, mentioned in 353, the custody belongs to the following persons in the order given below. In the absence of a mother, in the absence of other female relations, then the custody of the child will go to number 1, father. Number 2, the nearest paternal grandfather. Number 3, full brother. 4, consanguine brother. 5, full brother's son. Consanguine brother's son. Full brother of the father. Consanguine brother of the father. Son of the father's full brother. Son of the father's consanguine brother. 10 relations have been set out. So these persons will be entitled for the custody of the child in the absence of mother and other 10 female relations which have been set out in Article 353. Provided that no male is entitled to custody of an unmarried girl unless he stands within the prohibited degree of relationship. So if an unmarried girl, if the question of taking the custody of an unmarried girl comes, then the person who takes custody must be within the prohibited degree of relationship mentioned in Article 260 and 261 of Mohammedan Law. That we will see later. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . Then custody of child wife. Child wife, madhya hyphen illa. Child wife, that is a married minor girl. The mother of a girl who is married but has not attained puberty is entitled to the custody of a girl as against the husband of the girl. So when a girl is given in marriage to a man, the normal thing is the husband will be the caretaker. It is he who has to take care of the wife, and it is he who has to maintain her, nourish everything. But here, if that girl is a minor who is married and has not attained puberty, then she will not be given to the custody of the husband. It is the mother of the girl who has to be take care of that girl, and she will be the guardian. This is what Article 356 says. That is why I think in the same book, in one of the books written by Honorable Justice V. Ram Joyce, Eternal Values of Manusmriti, there his lordship goes on explaining. There is one Manusmriti shloka. Pita rakshati kaumarye bharta rakshati yauvanam rakshanti stavare putre nastri swatantra barhasi. ಈ ನಸ್ತ್ರೀ ಸ್ವಾತಂತ್ರ್ಯ ಮರಹಸಿ ಅನ್ನೋದನ್ನ ಎಷ್ಟು ಲೂಸಾಗಿ ನಾವು ಉಪಯೋಗಿಸ್ಕೊಂಡ್ಬಿಡ್ತಾ ಇದೀವಿ ಅಂತಂದ್ರೆ ಹೆಣ್ಮಕ್ಳಿಗೆ ಸ್ವಾತಂತ್ರ್ಯವೇ ಇಲ್ಲ ಅನ್ನೋ ತರ ಎಲ್ಲ ಭಾಷಣ. ಅದರ್ಥ ಅದಲ್ಲ ಅದು. ಅದನ್ನ ಸರಿಯಾಗಿ ಓದಿ ತಿಳ್ಕೊಂಡ್ರೆ, if you make a detailed study into that particular Manusmriti, you will come to know the value of that particular shloka. Of course, that if I want to explain that itself will take another 15 minutes. I don't want to do it. That is it. That shloka says, Pita rakshati kaumarye. When it only refers to a lady, woman, girl child. Pita rakshati kaumarye. When the girl child is in the stage of childhood or girlhood, it is the father who should take care. Bharta rakshati yauvanam. After marriage, it is the husband who has got to take care. Rakshanti sthavare putre. When that girl becomes old aged, then it is the son who should take care. That means it is not that women has no independence. It's not to interpret that the woman has no independence. We say that woman is a sacred jewel in the family. It is a sacred treasure in the family. So that women will have to be protected, safeguarded at all times. That is of course, there are a lot of interpretations to be given. That is the meaning of this. So here, custody of the child will not go to the husband. Custody of the child will be taken only by the mother because she has not attained puberty. Article 356. Then Article 357. A right of father and paternal male relations to custody of a boy over 7 years and girl who has attained puberty. The father is entitled to the custody of a boy over 7 years of age, that is above 7 years of age, and of an unmarried girl who has attained puberty. Unmarried girl who has attained puberty. So if she has attained puberty and married, she will be in the custody and control of the husband. If she has attained puberty and if she is not married, then and of an unmarried who has not attained puberty, failing the father, that is the father is not there, and the custody belongs to the paternal relations mentioned in Article 355 above, subject to the provisions to that section, to that Article 355. If there be none of these, it is for the court to appoint a guardian. So I told in the beginning itself that these are the persons, right from Article 352 to Article 356. These are the persons who are competent to be the guardian of a child, be a male or a female, under the law itself. So they can act as guardian of a minor child. But nothing prevents them from moving the court, making an application under the provisions of the Guardians and Wards Act, and get an order of appointing them as guardian. Nothing prevents. Even in the absence of such an order, they are competent to be the guardians. Article 357 says that when none of these relations are there, neither the mother nor the female relationship, neither the father or the other paternal relationship as mentioned in 1 to 10, then it is the court which has got to appoint a guardian. That is what Article 357 says. Then, Article 358. The custody of the illegitimate children belong to the mother and her relationship. And her relationship. Custody of an illegitimate children belongs to her mother or other female relationship and not relations and not to the father. This is Article 358. So, from Article 352 to Article 358, we are dealing with a situation where a custody of a Mohammedan child has to be given and to whom and in what order. Now, now custody of a property of the minor, that is under Article 359. Guardians of the property of a minor. So from 352 to 358, we have seen custody of a minor person. Now we have to deal with the property of the minor. The following persons are entitled in the order mentioned below to be the guardians of the property of a minor. Father, number one. Then, executor appointed by the father under the father's will. Father has written a will, he is dead. In that will, father nominates some person to be the guardian of the property of the minor. So that particular person will be the guardian of the property of the minor. Then number three, the father's madam, then the father's father. Father's father, that is paternal grandfather. Number four, the executor appointed by the will of the father's father. So if paternal grandfather has executed any will, and if in that will he has appointed any person as a guardian to take care of the property of the minor, that person will be the person who will be taking care of the who will be taking custody of the property of the minor and managing it. So Mohammedan law clearly says that property of a minor cannot be managed by a female relations. Property of a minor will have to be managed by the male relations only, because Article 359 does not speak of any female relationship. It says father, father's father, will executed by the father, will executed by the father's father. Guardian of the property to be appointed by the court. In default of the legal guardian mentioned in 359, 359 we have already seen father, father, executor of the father's will, father's father, executor of the will executed by the father's father. Only these four category of persons are considered as legal guardians to take custody of the property of the minor and manage and maintain it. In the absence of any of these four persons, Article 3 come into play. Article 360 says, in default of the legal guardian, Article 359, the duty of appointing a guardian for the protection and preservation of the minor property falls on the judge representing the state. So it is the duty of the state to take care of the minor. It is the duty of the state to keep in mind the welfare of the minor. Therefore, the state through the judge will appoint a guardian for the purpose of taking custody of the minor's property, maintain and manage them. Then 361, de facto guardian. We have seen above de jure, legal guardians. Now de facto guardian. A person may neither be a legal guardian under Article 359, nor a guardian appointed under Article 360. He may be called as a de facto guardian. A de facto guardian is one who is neither a legal guardian mentioned in Article 359, nor a guardian appointed by the court under Article 360. But may have voluntarily placed himself in charge of the person and property of a minor. Such person is called as a de facto guardian. Sometimes it happens. A person who is not either a legal guardian or a de facto guardian appointed by the court and having interest in the welfare of the child will assume the character of a guardian and conducts himself like that. But he cannot be either a legal guardian or a guardian appointed by the court, and he cannot exercise those power he can continue to be a de facto guardian only with a limited right. What is that limited right? We will see. A de facto guardian is merely a custodian of a person and property of a minor and nothing else. He is only a custodian. He is supposed to be in the custody of the minor. Sorry, he is supposed to be to take the custody of the minor and the property. Nothing else. He cannot meddle with the property, nor he can deal on behalf of the minor. Then Article 362, alienation of immovable property by a legal guardian. Instances may come that a legal guardian may have to alienate the property belonging to the minor. Then what are the factors to be considered? That is under Article 362. A legal guardian of the property of a minor, that is Article 359, has no power to sell the immovable property of the minor except in the following cases. So his power to sell is restricted by certain instances only. Number one, where he can obtain double the value. Today, the property of the minor is 10,000 rupees. By selling it, if he can make 20,000 rupees, it is for the benefit of the minor. Okay, you can do it. Number two, where the minor has no other property and the sale is necessity for his maintenance. Of course, he has to be maintained. Food and clothing will have to be provided. Education will have to be provided. Money is required. There is no other property left except this property. Then he can sell the property. Number three, where there are debts of the deceased and no other means of paying them. Deceased means the deceased parents. And there is no other means of paying them. Where there are legacies to be paid and no other means of paying them. Where the expenses exceed the income of the property. The property of the minor may be worth 10,000 rupees, but maintenance itself may cost 15,000 rupees. Then there is no meaning in keeping the property and making the minor a pauper. Therefore, under such circumstances, the property need to be sold. Where the property is falling into decay, and when the property has been usurped and the guardian has reason to fear that there is no chance of fair restitution. So these are the circumstances under which alienation of immovable property may be done by a legal guardian. I think there are one or two citations. I can give it at the end. Article 363. Alienation of immovable property by the guardian appointed by the court. So Article 362 is applicable for the legal guardians, father, person appointed as an executed by the father under the father's will, father's father, and person appointed under the will executed by the father's father. Now, when the guardian is appointed by the court under Article 360, what are his powers? A guardian of a property appointed by the court under the Guardians and Wards Act or under Section 360 has no power without the previous permission of the court to mortgage the property or to create a charge or transfer by sale or gift away the property or give the property in exchange or otherwise, and part with the immovable property to the, or to lease any part of that property for a term exceeding 5 years or for any term exceeding more than 1 year beyond the date on which the ward will cease to be a minor. This is very important. I mean, in some of the cases, this point will arise for a strong debate. For a or lease any part of that property for a term exceeding 5 years or for any term exceeding more than 1 year beyond the date on which the ward will cease to be minor. In the first clause, it is mentioned that a guardian can lease the property for a period not more than 5 years. That is controlled by the second clause by saying, however, if the minor is going to cease to be a minor and attain majority, such lease cannot extend beyond 1 year from the date of attaining majority. For example, today the minor is aged about say 16 years. The first clause says that as a guardian, I can lease it for 5 years. So if he is now aged 16 years, if I exercise that first power, then that lease will be in existence till he attains the age of 21 years. That is not the intention of the legislation. Within 2 years, that minor is going to become a major. So I cannot lease the property for a period more than 3 years, that is 1 year after he ceased to be a minor. So within 2 years from today, because now he is 16. Within 2 years from today, he becomes a minor. And after attaining majority, 1 more year is extended benefit is given. So a guardian can create a lease only up to the period of 3 years. He cannot take the benefit of the first clause and say, I have a power to lease it for 5 years, therefore I have leased it for 5 years. So that 5 years period has been controlled by the second part of the same clause. A disposal of immovable property by a guardian in contravention of the foregoing provision is voidable at the instance of the minor or any other person affected thereby. So, voidable means the person who has aggrieved can always challenge it as is not binding up. Void means it is void ab initio. It has no recognition in the eye of law at all, but it is voidable at the instance of the minor. Permission to the guardian to do any of the acts mentioned above must be granted by the court, except in case of necessity or for evident advantage, etc., etc. Then 364. Alienation of immovable property by a de facto guardian. A de facto guardian, that's 361, has no power to transfer any right or interest in the immovable property of the minor. Such a transfer is not merely voidable, but it is void. So a de facto guardian neither can sell, nor can gift, nor can mortgage, nor can create a charge, nor can give it in exchange, nor can give it on lease. He cannot deal with the property of a minor at all in any of the manners. And if it does so, it is void. That is, it is not at all recognized under the law. It is void ab initio. Article 365. Agreement by guardian for purchase of immovable property for his ward. Neither the guardian of a minor nor the manager of his estate is competent to bind the minor or his estate by an agreement for purchase of the immovable property. Such an agreement is void. I am the guardian of a minor child. I enter into an agreement with X, wherein I agree to purchase the property for a certain consideration on behalf of the minor. Whether I can do it, I can't do it. Because by entering into an agreement on behalf of a minor, I cannot bind the minor. Thereby, I am binding the minor to the particulars. They cannot do it. That is what Article 365 says. Power of a legal guardian to dispose of the property. 66. Legal guardian of the property of a minor has power to sell or pledge the goods and chattels of the minor. 367. Power of the guardian appointed by the court to dispose of movable property for legal necessity and benefit of the minor. Article 368. Power of de facto guardian to dispose of movable property. A de facto guardian has the power to sell and pledge the goods and chattels of the minor in his charge of the minor's imperative necessities for imperative necessities such as food, clothing, nursing. So a de facto guardian has got a limited power of selling only the movable properties of the minor for the purpose of meeting the necessities of the minor. Food, clothing, nursing, education, etc. So this is how the Mohammedan law explains so far as the custody of the child is concerned. So this is from Article 348 to Article 368 of this Mohammedan law. Now, who are all the persons who come within the prohibited degree of relationship? Article 260 of the Mohammedan law, prohibition on the ground of consanguinity, that is Rakta Sambandhigalu. A man is prohibited from marrying his mother or his grandmother, how high soever she may be. A man is prohibited from marrying a daughter or granddaughter. A man is prohibited from marrying a sister, whether full or consanguine or uterine. His niece or great niece, how low soever. His aunt or great aunt, how high soever, whether paternal or maternal. So these relations are called the relations which are coming within the prohibited degree under Article 260. Article 261. Prohibition on the ground of affinity. So, the prohibited degree of relationship comes within the two categories. One is on the basis of a consanguinity, and another one is on the basis of affinity. A man is prohibited from marrying his wife's mother or grandmother. A man is prohibited from marrying his wife's daughter or granddaughter. A man is prohibited from marrying the wife of the father, or paternal grandfather. A man is prohibited from marrying the wife of his son or son of his son, the daughter of his son, etc. So these are the persons who come within the degree of prohibited relationship. So Article 260 and 261 are to be kept in mind when we are talking about the persons in the degree of prohibited relationship at the time of giving custody of the child. So far as the jurisdictional aspect is concerned, in 2023 volume 1 civil court cases, Rajasthan, page 400, division bench, under the Guardians and Wards Act of 1890, Fordham Gaur versus Bajrang Gaur, dealing with the provisions of section 9 and 25 of the Act. It is said, custody of the child, jurisdiction of the court, exclusive jurisdiction to hear a suit for child custody under section 9(1) of the Guardians and Wards Act is the district judge having jurisdiction in place where the minor ordinarily resides. Where the minor ordinarily resides. In this case, child was residing within the jurisdiction of the district judge Merta, but the case was filed before the family court at Jodhpur. It was held that the family court at Jodhpur has no jurisdiction because the child was not residing within the jurisdiction of the family court of Jodhpur, and therefore it is only the family court at Merta where the child was residing which has got jurisdiction. So I think with this I have completed, not in detail, of course. I have not made a detailed description of each and every article because of the want of time and all that. Whatever the little thing that I have gathered, I have placed it before you. Thank you very much.
Sir, there are certain issues that you have raised. Leave alone the issues relating to discrimination against women and so on and so forth. That's a different subject altogether, whichever law it be. You have repeatedly used the word value-based education and you refer to certain Sanskrit texts. In our mediation process, the difference lies exactly there. What is value-based education is what is redefined by youngsters today. By the youngsters today. Parents who come to mediation fighting over the custody of children, this whole concept of value-based education, fundamentally the values have changed. How do we reconcile this? Is the first question. More, sir.
1 minute. I am also conscious of the fact which you have addressed, that it is very difficult for a child to get a value-based education in the present scenario. In the present scenario, I'll put a full stop there. But when I speak of the word value-based education, it does not necessarily mean the education that the child is going to get in the school.
Agreed.
The person who takes the custody of the child must see that the child is taught ethically and morally outside the academics also. One second, sir, let me complete. Outside the academics also. If you are thinking of getting a value-based education in the present scenario, I don't think the mean, because value-based education means it should be character building. Basically, it should be character building. personality building, building the capability of a person, all these things are included in the part of the value-based education. So in order to get such value-based education, the person who is in custody of a child must see that these education is given to that particular child on these principles also, at least outside the school.
Sir, the problem arises precisely there. The teacher, either the father or the mother, who is expected to impart this kind of value-based education, must accept those values as being a part of his life or her life. The problem we are facing in mediation, I'm not expecting you to give us a resolution. The problems most of us mediators face is this: to reconcile two opposing viewpoints where each parent has a different value system and has a different definition of value-based education.
Correct. I do agree. Value-based education, as you said, it varies from person to person, even from religion to religion also. But ultimately, what I mean by value-based education is to make a to make that particular person a good and responsible citizen of the society.
Yes, sir.
With that, I conclude.
If-
I don't
if-
think I can explain anything more for this. The whole duty of the parent or the guardian is only to see that that child is presented to the society as a good and responsible citizen.
That is where the problem arises. Good and
That's
responsible.
true, sir. That's
Sir,
true.
the second question for you. We have talked about welfare of the child. That is being the central theme of
Correct.
either the court or the guardians.
Correct, sir. Correct.
This is again the variable concept.
Is it the end of?
It's a variable concept again.
It is again variable, of course. is
Therefore, how I'm only reflecting to you what we face in mediation. For example, the father believes that the welfare of the child is satisfied if the child goes to a government school. The mother may feel that it is welfare of the child lies in sending it to Greenwood High. So these are conflicts we face.
No, yes, sir. Yes. Over?
No.
No. Your question is over, no? Your question is over. See, my answer to this question is only this much. It is the mediator who has got to play a major role in this. In the sense, of course, you cannot be a conciliator. I know that. Mediator can never be a conciliator. Mediator will have to be a silent spectator, making a congenial atmosphere for both the parties to sit across the table, discuss and decide about the issues concerned. But nothing prevents a mediator by giving proper advice. According
No,
to
we
me, if I am
can't.
correct.
We can't.
Even that is
we
not
can't. We
that is
can't.
not that is not
We
permissible.
can't.
That is not
Because the
permissible.
moment we give advice, we are imposing our value
Correct.
system on.
Correct. That is not permissible.
No, sir.
Okay.
Anyway, no, we can't even enlighten. We have a different technique, sir.
Correct.
We have something known as reality testing also. That's different, sir. And the third question, sir. There are certain class of people who are mentioned as guardians and in the absence somebody else. Can we contract outside of that law?
That depends upon as a mediator. I cannot answer
No,
this
no, no.
question.
Can we? Like, for example, in industrial law, in legislation, contracting out of the Provident Fund Act, the Workmen's Compensation Act is prohibited, statutorily prohibited. So now if under article, one of those articles, the father is to be the guardian, is a mediated settlement which says the mother shall be the guardian permissible?
Just now you said that a mediator cannot open his mouth.
Don't open my mouth.
Ah.
They agree.
If
The parties agree.
If they agree.
to
If
contract
if
outside.
they agree.
Yeah.
If they mutually agree, fine.
You can contract outside.
That is the duty of the mediator. If mutually they agree, you have no business to interfere with that.
But it has to be in accordance with law. The agreement has to be in accordance with law.
Ultimately, it is to be decided by the court.
That is passing on
Yes.
responsibility. That's
No. That's all what you can do as a mediator. You have no other power. As Madam has put it, you cannot even suggest them. You cannot even advise them.
No, sir, but can they contract outside the law? Unlike the industrial law, outside of the law, if the law says the father shall be the guardian under 368 or whatever the provision.
You are talking about a compromise outside the court.
Yes, can
Outside
we
the court.
contract
It's
outside?
for the parties to decide. It's for the parties to ultimately it is for the court to accept it. Even if mediation is arrived here, some solution is arrived here, ultimately it is for the court to accept it.
Sir, that is true in the case of court annexed mediation.
Correct. So even outside also, if supposing the compromise that is entered into outside the court is not legal, you can't expect the court to accept it.
That is, no, we don't go to court at all. For example, sir, in the today's mediation world, there is pre-litigation and private mediation that is going on.
Correct.
Now
mediation
there
pre-litigation ಇದೆಯಾ?
pre-litigation ಇದೆ, private mediation ಇದೆ, cross-border online mediation
I am not
ನಡೀತವೆ.
aware. I am
No,
not aware.
I'm giving you the
Okay,
example.
okay.
So in the pre-litigation
Because
mediation,
pre-litigation, I know that it is in Legal Services Authority.
ನಮ್ದರಲ್ಲಿ private mediation ಬರ್ತಾರೆ.
Okay.
Now, if there are two Mohammedans who come for private mediation and they agree that notwithstanding one of those articles, instead of the father, the mother will have custody and be the guardian.
No, sorry, I am not aware of the private mediation.
Fair enough.
I have not looked into it. I am sorry. I am not able to answer
Fair
the
enough,
question
sir.
because I have not looked into the provisions of the private mediation at all.
Ma'am, one suggestion to all of us here as mediators, the takeaway for us perhaps is that whenever we deal with custody cases in respect of Mohammedans, it may make sense for us to convince them that irrespective of what the law says, file an application under the Guardianship and Child Act and get an order. That may make sense so that it becomes completely legal without any scope for discrimination. Thank you, ma'am. I'm sorry I've taken so much time.
Are there any questions from mediators of Dharwad and Gulbarga bench?
Good evening, ma'am. From Dharwad bench, we do not have any questions.
From Kalburgi?
No, madam, there is no question.
No question.
Kalburgi.
Thank you. So recently, one of you had a problem where mother wanted to go to Sri Lanka to meet her relation. Father was not alive. The daughter had attained puberty and the son was a minor or so. Daughter was around 17 years old. The mother was ready to hand over the custody of the child to her husband's elder brother also, and actually the children were not brought to court. They were not brought to mediation center, and there was no document to say that this man who was ready to have the custody of the child was the father's elder brother. So this is where the situation like the one Mr. Shivkumar was. Yes.
Mother as a mother I have already read Article 352 as per which the mother has a legal right to be in custody of a male child who is under the age of 7 years and in the custody of a female child who has not attained puberty. There is a mention in the book itself that at times it so happened that the mother may be leading a life which may amount to a misconduct. I hope all of us can understand. Under such circumstances, it is only the court which has got to appoint a guardian. Because mother is there. It is not as if 353 will come into picture, because if mother is not there, in the absence of the mother, that's a different matter. But mother is there. But mother is disqualified because she is of a lady of having some misconduct. Then I think the only authority which can appoint a guardian is the court, according to my knowledge.
Thank you, sir. In that case, the mediator did the same thing and the matter was sent back as not settled for the court to decide. Yes. Thank you.
Thank you very much for providing this opportunity.
Honorable Shri D.R. Venkatasuresan sir has taken us through the different nuances and niceties of child custody under Mohammedan law. Hence, I, on behalf of Karnataka Mediation Centre, extend my heartfelt thanks to Shri D.R. Venkatasuresan sir. I also request Shri Shivkumar sir, senior mediator and master trainer, to offer the book as a token of gratitude to Shri Venkatasuresan sir. Thank you. I also extend my heartfelt gratitude to President and Board of Governors of Karnataka Mediation Centre. I also extend my gratitude to Registrar Computers, Additional Registrar General Kalburgi and Dharwad bench, Additional Registrar Judicial, Kalburgi and Dharwad bench, and also to Honorable Director, Karnataka Mediation Centre, and also to trainers, master trainers, and all the mediators who are present here, and all the mediators across the state who are watching this program through virtual mode. I thank each and one who cooperated us for making this program very success. Thank you one and all.